I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. The 11th Circuit Court of Appeals has finally made its ruling that federal judge Aileen Cannon improperly asserted equitable jurisdiction in the Donald Trump stolen document case. They have reversed her order asserting equitable jurisdiction, and they have demanded that she immediately dismiss the case. This means that the special master process, which emanates from Judge Aileen Cannon improperly and unlawfully asserting equitable jurisdiction, that process ends. Judge Aileen Cannon is off the case. Look, it's possible and probable Donald Trump will probably try to file some emergency application with the United States Supreme Court to try to block or vacate the ruling by the 11th Circuit Court of Appeals. He's already lost when he attempted that before, where the 11th Circuit Court of Appeals had previously granted the Department of Justice's motion for partial stay a few months back, returning the 100 classified records that Donald Trump stole. So this was the overall appeal, though, with respect to the remaining 11,000 or so documents that Donald Trump stole. Remember, the Department of Justice got back those 100 classified records when they made that emergency motion to stay to the 11th Circuit. And here, the 11th Circuit, in their ruling that just issued, stated that Judge Aileen Cannon should never have asserted equitable jurisdiction in the first place. And what the 11th Circuit Court of Appeals did is they explained, look, equitable jurisdiction, or anomalous jurisdiction, as it is sometimes phrased, should only be exercised in the most extreme circumstances, in the most exacting circumstances, in the most rare circumstances where the government engages in such an unlawful abuse of the rights of someone it's investigating that a federal judge needs to step in where they don't otherwise have any legal authority or statutory authority at all to do so, and basically jump in and say, hey, we need to press pause for a second because the government has gone rogue. And there's a test that the 11th Circuit has borrowed from the 5th Circuit. I won't totally geek out here about why the 11th Circuit followed 5th Circuit precedent, but when the courts expanded, the 5th Circuit precedent kind of held over to the 11th Circuit Court of Appeals. But the different Circuit Court of Appeals across the country use their own tests for when a federal court can assert anomalous or equitable jurisdiction. And they're all different, but they're basically the same kind of factors when you really break it down. They may be stated slightly differently. And the test in the 11th Circuit Court of Appeals is from a 1975 case called Ritchie. That's why it's called the Ritchie factors, because that's what the case was called. And what the Ritchie test is it says, number one, did the government engage in a callous disregard for the rights of the person that they are investigating? In other words, not only did the government engage in unlawful conduct, but that it was so callous, so blatant that a federal judge needs to step in pre-indictment to kind of block the Department of Justice's ongoing criminal investigation, versus where remedial relief would normally occur, which is post-indictment, whether it's a suppression motion or another type of motion addressed to the judge once an indictment actually takes place. And here, what the 11th Circuit found, and frankly what Judge Aileen Cannon found, is that there was no callous disregard at all for the rights of Donald Trump. Look, the Department of Justice got a valid search warrant from a magistrate judge, Judge Reinhardt, who signed off, who found probable cause. The Department of Justice executed the valid search warrant on August 8th and found the stolen records that Donald Trump stole. No callous disregard. In fact, nothing unlawful that the Department of Justice engaged in at all. That alone alone should be a threshold inquiry, the 11th Circuit Court of Appeals has held. And you don't even need to look at the other factors, because if there's no callous disregard, the court should not assert equitable jurisdiction at all in the first place. But the court said, look, let's look at the other Ritchie factors as well, because under any of the factors, Judge Aileen Cannon should not have asserted equitable jurisdiction. So one of the other factors is the irreparable harm that would befall the person being investigated. In this case, the 11th Circuit Court of Appeals said, what was the irreparable harm that Donald Trump would face? He stole these records that didn't belong to him. What irreparable harm would he have of these records which don't belong to him staying with the Department of Justice? Or that what irreparable harm exists for the Department of Justice to take back the records that Donald Trump stole? There is no irreparable harm here for the thief who steals the whatever they steal, whether it's the records or the money, and then says, you know what, I want it back. Like the bank robber who steals the money, the Department of Justice gets it back, and they're like, I'm going to be irreparably harmed if I don't get the money back that I stole from the bank. It's like, what? Look, the 11th Circuit didn't use that analogy, but that's essentially what their ruling is saying. Like, Donald Trump didn't have any irreparable harm here at all. One of the other factors then is the need for the individual to get the records back. And here, the 11th Circuit Court of Appeals said that there is no need at all for Donald Trump to get these records back because they're the current executive branch records. They're Biden's records. The records do not belong to Donald Trump. He can't have a need to have these records back. And what Judge Aileen Cannon basically held is like, look, there's special circumstances that exist for former presidents like Donald Trump, and we need to protect Donald Trump's reputation. And what the Department of Justice could be doing here is harming Donald Trump's reputation. So that's why I find irreparable harm, and that's why I am bringing in a special master. And that is utterly preposterous. No one is above the law. And frankly, that's what the 11th Circuit Court of Appeals said here as well, that nobody is above the law. And what the 11th Circuit Court of Appeals said, look, only one possible justification for equitable jurisdiction remains, after they basically say all these factors of the Ritchie test don't apply here. There shouldn't be equitable jurisdiction under all of our case law and precedent. So there could be maybe one other explanation that we can talk about. So they go, only one possible justification for equitable jurisdiction remains, that plaintiff is a former president of the United States. It is indeed extraordinary for a warrant to be executed at the home of a former president, but not in a way that affects our legal analysis or otherwise gives the judiciary license to interfere in an ongoing investigation. The Ritchie test has been in place for nearly 50 years. Its limits apply no matter who the government is investigating. To create a special exception here would defy our nation's foundational principle that our law applies, quote, to all without regard to numbers, wealth, or rank. I want to read that one more time because I think it's just such a powerful line. To create a special exception here, to treat Trump as somehow different from ordinary citizens here, would defy our nation's foundational principle that our laws apply, quote, to all without regard to numbers, wealth, or rank. And that cites a 1794 case, State of Georgia versus Brailsford. The 11th Circuit Court of Appeals goes on to say, the law is clear. We cannot write a rule that allows any subject of a search warrant to block government investigations after the execution of the warrant. Nor can we write a rule that allows only former presidents to do so. Allowing that to happen would be incredibly problematic and would defy our nation's founding principles. Powerful words there by the 11th Circuit Court of Appeals. And look, We have been talking about this case for a very long time on the MeidasTouch network because it was so unprecedented what Judge Aileen Cannon did when she granted this bizarre motion for judicial oversight that Donald Trump had filed in late August after the search warrant was already executed and probable cause was found by the magistrate Judge Reinhardt on August 8th. And on September 5th, Judge Aileen Cannon, who was appointed by Donald Trump, and she's not an experienced judge, but she ruled that she had equitable jurisdiction here. And what we had been saying on the MeidasTouch network and other legal commentators had been saying is like, this had never happened before. You have a federal judge interfering with the separation of powers. It's against all case law, all precedent, and common sense for the federal judge to block the Department of Justice's criminal investigation, to stop the executive branch after they have a warrant where probable cause is found. And it imperiled our nation as well. We should never forget that, because the documents that Donald Trump had stole, many of them were top secret, sensitive, compartmented information, our nation's highest secrets. And so by depriving the actual Department of Justice, the current executive branch of that, allowing somebody to steal those records, not just imperiled the criminal investigation, but also imperiled all of our lives. It placed the national security of our country at jeopardy to appease the frail ego of the individual, of the cult leader who appointed this judge, who appointed Judge Aileen Cannon. And the Department of Justice played this out perfectly. They filed that very surgical motion for an emergency motion for a partial stay to get back those 100 classified records right away. The 11th Circuit ruled that Judge Aileen Cannon didn't have equitable jurisdiction a few months back. Those documents were returned to the Department of Justice. And then we had said here on the MeidasTouch network, look, the same analysis by the 11th Circuit panel there. Granted, it was a different panel here, but there a unanimous 11th Circuit Court of Appeal panel found that Judge Aileen Cannon shouldn't have asserted equitable jurisdiction because none of the Ritchie factors were met, and that anomalous, that extraordinary jurisdiction should never have been asserted based on anything that had happened here, and that there was no precedent for this type of jurisdiction by a federal judge to ever be asserted. So we had said, look, those same factors will apply not just to those 100 classified records that were at issue there, but also with respect to the remaining 11,000 records. And so then the Department of Justice, after surgically getting those records, they filed a motion to expedite the appeal process for the overall appeal of Judge Aileen Cannon's equitable jurisdiction assertion. That was granted by the 11th Circuit Court of Appeals. Then there was oral argument, which was held, a few weeks ago at this point, which was a very kind of quick oral argument to be held. It was in front of a different panel, but a panel made up of two Trump appointee judges and one George W. Bush appointee. And those individuals basically all ruled in a per curiam decision, in a unanimous decision, that these records should go back to the Department of Justice, that Judge Aileen Cannon should never have asserted equitable jurisdiction. And so what does that mean now for the special master process? Well, as I said at the outset of this video, the special master process emanated from, it arose out of the frivolous and unlawful assertion of equitable jurisdiction, right? So when Cannon said that she had equitable jurisdiction on September 5th, she then brought in the special master as part of that improper, anomalous, or equitable jurisdiction. And now that is going to come to an end immediately as well. Look, Judge Raymond Dearie carried out his work very dutifully and showed how a judge should act in these circumstances, in stark contrast to Judge Aileen Aileen Cannon. And Judge Raymond Dearie, the special master, was very critical at all stages of Donald Trump's lawyers playing these games, even though he was the one recommended by Trump's lawyer to become the special master. When Judge Aileen Cannon asked the parties to submit recommendations, Judge Raymond Dearie was like, what are you talking about? Stop playing games in my court. What are you asserting executive privilege and that these records are personal at the same time? Like, stop with the games. What's the real dispute here? At one point, the judge was like, where's the beef here? What's going on? I don't want games in my court. And so Judge Raymond Dearie carried out his work dutifully in the very odd circumstances of Judge Aileen Cannon overruling him, and she engaged in very bizarre rejections of his orders, but he carried out his work. But that process now comes to an end, and the Department of Justice has been able to pursue its investigation regarding with the critical documents, because they got those 100 classified records. So at the end of the day, Donald Trump has spent hundreds of thousands and potentially millions of dollars to lose. Judge Aileen Cannon has sacrificed her entire reputation. Everything Trump touches goes to you know what, and Judge Aileen Cannon's reputation got flushed down the toilet as well in this ridiculous endeavor. Now, Donald Trump will likely, as I said at the outset of this video, file some emergency application with the United States Supreme Court to try to vacate the 11th Circuit's per curiam or unanimous decision, but he is going to lose that the same way he lost before when he did that. It's possible, Clarence Thomas is the judge who oversees emergency applications before the 11th Circuit Court of Appeals. It's possible that Clarence Thomas orders the Department of Justice to submit briefing. We've seen that across the country where emergency applications regarding Trump or regarding January 6th related litigation has gone to the Supreme Court on emergency basis. So don't worry if that happens. That's part of the normal process where he may ask for briefing or temporarily stop the 11th Circuit's order pending a full briefing. But Donald Trump is going to lose. He's lost in the 11th Circuit. He will lose if he does go to the Supreme Court. This is a big, humiliating loss for Trump, a big, humiliating loss for Judge Aileen Cannon, and a very good day for justice. I'm Ben Meiselas from the MeidasTouch Network. Hit the subscribe button right now. We are on our way to 1 million subscribers thanks to your support. We just passed 700,000 subs. Now we're at 750. Let's try to get to 1 million by the end of the year. So please hit subscribe right now. Also, consider becoming a patron of the MeidasTouch Network. Go to patreon.com/MeidasTouch, patreon.com/MeidasTouch. There's lots of exclusive content you can only get at patreon.com/MeidasTouch. But most importantly, we are not funded by any outside investors at all. So we are 100% independent, 100% accountable to you. And I always get asked by you, wherever you are in the world, if you want to help grow this thing, this community, this network, go check out patreon.com/MeidasTouch, patreon.com/MeidasTouch. Until next time, I'm Ben Meiselas.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.MeidasTouch.com. That's store.MeidasTouch.com.